Good morning. In the previous lecture, we have seen legal rights. Okay, we have seen essentials of right and definition of right. Okay, today we are going to discuss the kinds of legal rights. The first is perfect and imperfect right. What we are going to do? We are going to see or discuss two rights at a time. Okay, perfect right and imperfect right. What is a perfect right? Perfect right is that which corresponds with a perfect duty. Then what is a perfect duty? Perfect duty means the duty which can be enforced with the help of law, which can be enforced by the court. Means it is perfect duty is not merely recognized but also enforced by law. That is called as a perfect duty. Now when there is a perfect duty, corresponding to it is a perfect right. Okay. Now imperfect right means what? It is corresponding with a imperfect duty, means that duty cannot be enforced by the court. Okay. Now if it is a time barred debt, what will happen? When the plaintiff files a case against the defendant, and if the matter is time barred or the debt is time barred, the court is going to dismiss the matter, isn't it? Means this, though the debt was there, though money was given, plaintiff is entitled to get the money, but he can't get it from the court because he is late. He has made delay. He has filed a case outside the limitation period. Therefore, defendant cannot be compelled by law to repay the debt. Therefore, this is a imperfect duty. So, his right to recover the money becomes imperfect. Now, if the plaintiff comes within time and all, then the court is going to enforce the duty. That the court is going to compel the defendant to pay the money, to repay the debt. It means here it is enforceable. Therefore, it is a perfect duty. Therefore, there will be a perfect right. Okay. Perfect right corresponds to perfect duty. Perfect duty is not merely recognized but also enforced by law. Not enforced and not recognized will be called as a imperfect duty. Corresponding to it, there will be imperfect rights. The claims which are barred by limitation, they can't be enforced by the court. Therefore, it is imperfect, isn't it? It is imperfect. Therefore, the right will be imperfect. Now, imperfect right, maybe you can say good as a ground of defense, though it is not good as a ground of action. If imperfect right is there, I can't file a case against you. Though I file, the matter will be dismissed. But it can be taken as a good defense. Means the defendant can say that, see, this is time barred. So, imperfect right is good as a defense. It is not good as a claim. Got it? Therefore, it is perfect right and imperfect rights. Now, second is positive and negative right. Now, according to Salmon, what is positive right? Positive right is that which corresponds with the positive duty and entitles its owner to have something been done. Means I will compel you to do something. When you are going to do something for me, then that is a positive duty, and therefore I am having a positive right. It entitles its owner to have something done for him without the performance of which his enjoyment of right is imperfect and incomplete. While negative rights have negative duties corresponding to them and enjoyment is complete unless interference takes place. Means my right to performance of a contract of service is positive. Means servant, you can say, you take an example of a servant and a master. Master is having a right that his servant should serve him for that particular period. He has to do the work. So this is doing of a work. Therefore, it is a positive duty. Therefore, master's right will be positive right. Got it? But when a person can enjoy his right only when the other person does not do something, then that is called as a negative right. For that, Salmon has given one example. If another person owes some money to me, my right to money in his pocket is positive. Means if I owe you some money, means I have to give you the money. So you are having a right, positive right, to compel me to give you the money. Means your right is positive right. Okay. If I have some money in my pocket, my right is negative. Means if you are having money in your pocket, it is your money, you can enjoy it. But when you can enjoy it, when other persons do not steal it. Do not steal it. That is negative. Okay. So if other people don't interfere, then you can enjoy your money. You can enjoy your right. That is called as a negative right. Positive right and a negative right. Okay. Now real right and personal right. Real right corresponds to duty which is imposed to persons in general. It is imposed upon persons in general. When all the people are having duties towards me, then that my right will be a real right. Personal right corresponds with a duty which is imposed on a particular person. If you make a breach of contract, we both have entered into contract. If you make a breach of contract, then I can file a case against you only, not others. So this is my personal right. When the right is like against the whole world, just in rem, then that is called as a real right. I have a real right against everyone not to be deprived of my reputation. Therefore, this is a real right. But if somebody makes a breach of that, defames me, then I am having a personal right to file a case of defamation for getting compensation. Got it? Means my right to reputation is against the whole world. Nobody should interfere. Nobody should defame me. Therefore, that is a real right. But if you do that, then I will file a case against you for getting compensation. That is my personal right. Okay. Now the next is proprietary right and again personal right. What are proprietary rights? Ownership rights, on which you can exercise ownership like estate and assets and all. Now these proprietary rights are having economic value, you can say monetary value. So those are, you can say, valuables. That is having an element of wealth, isn't it? Therefore that is called as a proprietary right. Means I can exercise my ownership on certain things. Then I am having a proprietary right. Now personal right. What is a personal right? Like a right to enter into a contract, right to make a will. Now these rights are personal in nature. They are of judicial importance. They are not having that economic value and all. Okay, therefore they are personal right. They are not economic, they are not having economic value. They are having judicial value. They are having judicial importance. These rights are very much essential for well-being, isn't it? Right to marry, that is a personal right. While right to enter into contract, right to, you can say, right to property, right to sell and all, those are proprietary rights. Got it? This is proprietary and monetary rights. Next is inheritable right and uninheritable right. Inheritable rights means rights which can be herited, the right which survives the owner. You can say like the proprietary rights are inheritable, means heritable rights, while personal rights like right to marry and all, those rights are going to die with that person. Therefore those are uninheritable. When the owner dies, the rights come to an end. These are uninheritable. Legal representatives don't get these rights. Inheritable rights, it can be inherited. It will go to the legal representative, a right which survives the owner. That is called as inheritable right. That is personal right. Okay. Now the next is what? Right in re propria and right in re aliena. Right in re propria means my right to hold a land, proprietary rights. Okay. Right in re propria, my right on a land, it is re propria. Right in re aliena. Re aliena means other persons having a right on my land, and therefore my right of re propria is being restricted. Means that is called as right of re aliena. Or you can say when I am having my land, I am the owner, that right on my land is right in re propria. But if I am having a right of an easement to right of way on others' land, then that is right in re aliena. Right of way across another's land is re aliena. Right in re aliena or encumbrance is one which limits or derogates from some other general right belonging to some other person in respect to the same subject matter. I am having a right of land, dominant owner I am. Okay, therefore that is right in re propria. I am having a right over others' land means I am going to limit the others' land, isn't it? His right of ownership, because easementary right will be exercised on his land. That right is called as right in re aliena. Okay, this is right in re propria and right in re aliena. Okay, now next is principal and accessory rights. What are principal rights? Principal rights exist independently of other rights. Right to enter into contract. It is just a right. It does not depend upon anything. Anything in the sense, any other rights. Principal right exists independently of other rights, while accessory rights are appurtenant, are connected to other rights. They give beneficial effect on the principal rights. When they are giving beneficial effect on other rights or principal right, that is called as accessory right. A security is accessory to the right secured. Okay, you can say right of land or right of ownership is principal right, but somebody encroaches it, somebody trespasses it, then you are having full right to file a case against him. This right is connected to the main right, that is accessory right. Principal debt is a principal right, right to recover the money and all, that is a principal right. Right to hold the security, that is a accessory right. A security is accessory to the right secured. Debt is a principal right, and the security in the form of a mortgage and all or a pledge and all, that is accessory right. Okay, we have not yet completed the kinds of rights. We will continue in the next lecture. Okay, bye bye. See you in the next video.